Wow, so, but I'm sure, all these peoples, because a lot of them, when they apply for visas or when they want to work abroad, they don't, I can't call it lack of information, because sometimes they don't know that they just want to get in, right? They just want to take a job or get a job. Because of the lack of information, they don't know that this is a rule, under which you're not allowed to pay or you cannot pay. So, but then, John, is it a rule? I mean, are people aware about this?
So there are certain rules prohibiting payment to employers. Usually that's in the H-1B context where it's explicitly clear you can't pay for the attorney fees and you can't pay for any of the fees associated with the petition or the LCA preparation. This is a little different. There's really nothing on point saying that you can't pay somebody for training, you can't pay for marketing or what have you. The, you know, what USCIS tries to do is they try to, when they do site visits or at the port of entry with CBP, is they try and force you to say that you didn't pay for the training, you paid for an offer letter. And if you paid for the offer letter, then boom, they say you're guilty of fraud. But they assume everybody paid for an offer letter. And they ignore the fact that, the representation that was made to them was you're paying for training so that we can then market you for contracts that, the company would make money on, presumably. And so, what USCIS considers to be fraud doesn't really match up with the definition of fraud that's in the law.